Welcome back to Courtroom Chronicles, the podcast where we dive deep into real-life legal dramas from India's courts. I'm your host, Shiv, and today we're unpacking a fresh Supreme Court judgment from August 26, 2025. It's a case that pits workers' provident fund rights against big banks' loan recoveries. Think of it as a tug-of-war over who gets paid first when a company goes bust. The case is MS Edelweiss Asset Reconstruction Limited versus Regional PF Commissioner 2 and Recovery Officer Bengaluru. We'll break it down step by step. What the case was about, the evidence presented, what happened in court, the conclusions, the final judgment, the moral of the story, and key lessons for the common people. Grab your headphones. This one's a roller coaster of corporate defaults, auctions, and legal priorities. Segment 1. Setting the scene. What was this case about? Let's start from the beginning, like any good story. Our main character is a company called MS Acropetal Technologies Pvt Limited, based in Bengaluru. They were a tech firm, but like many businesses, they hit rough waters. From July 2013, they started defaulting on paying Provident Fund (PF) dues for their employees. Provident Fund, as you know, is that mandatory savings scheme where employers and employees contribute for retirement security. It's governed by the Employees Provident Fund and Miscellaneous Provisions Act, 1952, PF Act. The Employees Provident Fund Organization EPFO, the government body overseeing this, swung into action. They launched an inquiry under Section 7A of the PF Act. After hearings on June 8, 2015, they slapped Acropetal with a bill of Rs. 128,90,486 in unpaid PF dues. And that wasn't all. It didn't even include interest and penalties under Section 7Q and 14B of the Act. The total dues ballooned to over Rs. 2.96 crores by mid-2015. Acropetal was in deep trouble. Their bank loans were declared non-performing assets, NPAs, meaning they couldn't pay back banks either. Banks like Axis Bank, State Bank of India, SBI, and State Bank of Travancore, now merged with SBI, started auctioning Acropetal's properties to recover their loans under the SARFAESI Act, Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, 2002. This law lets banks seize and sell assets without court intervention for quick recovery. The plot thickens. EPFO claimed first charge on these properties under Section 11(2) of the PF Act, meaning PF dues should be paid before bank loans. But banks, especially Axis, argued their secured loans had priority under Section 35 of SARFAESI. 3 properties were key. 1. Acropetal property, auctioned by Axis Bank in March 2016 for about Rs. 12 crores. Axis kept the money, saying their dues weren't fully paid. 2. Kamanahali property, auctioned by Edelweiss Asset Reconstruction Company, EARC, the appellant here, who took over SBI's loans. 3. Palia property, also auctioned by EARC from State Bank of Travancore. EARC sold the 2 properties for about Rs. 7 crores total. EPFO demanded payment from EARC too, leading to attachments and recoveries. ERC paid Rs. 75 lakhs under court order but challenged further demands, saying Axis should pay the rest proportionally. The core issue? Who has priority? EPFO's PF dues or banks' secured loans? ERC filed a writ in Karnataka High Court which dismissed it on February 1, 2024, ordering the Rs. 75 lakhs to go to EPFO. ERC appealed to the Supreme Court. End of Segment 1. Segment 2. The evidence presented. What was shown in court? Now let's talk evidence. This wasn't a trial with witnesses or dramatic cross-examinations. It was more about documents, letters, and legal interpretations. Key evidence pieced together from the judgment. EPFO's orders and communications. The June 8, 2015, order determining Rs. 1.28 crores dues. Letters from EPFO to banks, for example, July 8, 2015, to Axis demanding Rs. 2.96 crores. Attachment order on Acropetal property, July 23, 2015. Reminders and demands to EARC in 2021 to 2022 for Rs. 2.08 crores, later adjusted. Acropetal's letters, their June 29, 2015, Letter admitting defaults, informing about auctions, and requesting EPFO to ask banks for direct payment. Bank responses. Axis' July 20th, 2015. Letter claiming priority under SARFAESI Section 35. Their post-auction letter saying no surplus left after their dues. ERC's January 27th, 2023. Letter offering Rs. 78.43 lakhs as full settlement. Court orders. Karnataka High Court's interim stay in a related writ, October-November 2015, that halted Axis' auction temporarily. Another High Court order staying EPFO's Rs. 1.30 crores penalty demand under Section 14(b). Financial figures. Auction proceeds Rs. 12 crores from Axis' sale versus Rs. 7 crores from ERC's. Total EPFO dues. Basic Rs. 1.28 crores plus penalties Rs. 1.30 crores plus interest. Legal precedents. EPFO cited Supreme Court's Maharashtra State Cooperative Bank versus Assistant PF Commissioner for PF Priority. Banks leaned on SARFAESI's non-obstant clause, Section 35, which overrides other laws unless specified. No physical evidence like photos or videos. It was all paper trails showing timelines of defaults, auctions, and competing claims. The Supreme Court noted materials on EPFO's prior charge creation before auctions. Segment 3, What Happened in Court, the Arguments and Drama, fast forward to the courts. First, Karnataka High Court, writ petition number 2543, 2023. ARC challenged EPFO's attachment and demands. They argued proportionality. Since Axis got more from auctions, they should pay more of EPFO's dues. High Court dismissed it on February 1, 2024, saying EPFO has priority and ordered the deposited Rs. 75 lakhs to EPFO. No deep dive into Axis' role since Axis wasn't a party. Supreme Court appeal heard on August 26, 2025. Justices Vikram Nath, Sanjay Karol, and Sandeep Mehta presiding. ERC's arguments by Senior Counsel Krishnan Venugopal. Admit EPFO's first charge but say it's unfair. We paid our share. Rs 75 lakhs proportional to our Rs 7 crores sale. Axis sold for Rs 12 crores, so they should cover the rest, including the stayed Rs 1.30 crores penalty. EPFO's stand by Dushyant Parashar. High Court was right. We can recover from anyone. Axis not impleaded in High Court, so no relief there. Demand full balance. Axis Bank's defense by Senior Counsel Gopal Jain, impleaded in SC. SARFAESI. Section 35 gives us overriding priority as secured creditors. PF dues are like government taxes. We pay only after our loans are cleared. No recovery from us till our dues are satisfied. The bench noted RC's mistake in not impleading Axis earlier, but allowed it in SC. They focused on the need to resolve the first charge debate properly. They required all parties to be on record so the priority issue can be adjudicated with everyone present. End of segment 3. Segment 4. The conclusion and judgment. What was decided? The Supreme Court didn't decide the priority war itself. Instead, they set aside the High Court's order and remanded, sent back, the case to Karnataka High Court for a fresh look. Key conclusions. EPFO has a strong claim under PF Act Section 11(2) for first charge on assets. But SARFAESI. Section 35 might override, giving banks priority as secured creditors. Proportionality argument by ERC has merit, but needs all parties, including Axis, involved. Judgment, appeal allowed, writ petition restored. High Court must implead Axis Bank, allow pleadings, hearings, and decide priorities considering EPFO's pre-auction charges. All contentions open, no costs mentioned. In simple terms, Supreme Court said, High Court, you decide this properly with everyone at the table. Segment 5. Moral of the story and lessons for the Aam Janta. Moral: in the world of debts, not all claims are equal. Workers' rights, like PF, are sacred, but banks' secured loans have muscle too. Delaying payments can lead to a messy web where everyone fights over scraps. Early communication and settlements save headaches. Lessons for common people. Aam Janta. 1. For employees. Your PF is protected by law. Employers can't skip it without consequences. If your company defaults, EPFO can fight banks for your money. Check your PF passbook regularly via the EPFO app. 2. For borrowers and business owners. Don't let loans become NPAs. If you're auctioning assets, inform statutory bodies like EPFO early. They might claim first dibs. Understand laws like SARFAESI. Banks can seize fast, but PF dues linger. 3. For lenders, investors. Secured creditors aren't invincible. PF Act can trump you if not handled right. Always check for prior charges before auctions. 4. General guidance. In legal fights, implead all parties early to avoid remands. For AM Janta, if facing similar issues, consult a lawyer or use free legal aid. Remember, courts prioritize social welfare, like PF for workers, over pure commerce, but balance is key. This case highlights how laws evolve. Expect more clarity on PF versus SARFAESI post-High Court decision. Outro music fades in host. That's the end of this episode. What do you think? Should PF always win? Drop your thoughts in the comments. Subscribe for more legal stories. Until next time, stay informed. End of podcast.